Once again, welcome everyone. If you don't know who I am, I'll introduce myself just a tiny little bit in a moment, but I am Scott Collins, an elder law attorney. My law firm is Elder Law Guidance here in Richmond, Kentucky. I will talk about Medicaid tonight and rules about residents' rights, which are really protected from a federal level. So there's always this issue of, will this apply to me if I'm not in Kentucky? I'll try to make that clear. And if not, you interrupt me and ask me specific questions about where you may be coming from. But we are talking about Medicaid in Kentucky, specifically of Medicaid. What are the qualification standards? Can I make it? But why would they be calling you anyway? So I want to touch a little bit on guardianship. I want to talk a little bit about adult protective services. That can be a concern where you could get a call, or just what even happens as you're going from, let's say, the hospital to a skilled nursing facility. You didn't expect that was even going to happen for you or your loved one. And what does that mean? How does Medicare apply to all of these sorts of things? So it's going to be kind of an interesting little journey that we're going to take tonight over the next hour. You'll see there on the slide ways to get in touch with us. So the email you received tonight is a great way to respond to us. info@Elder Law Guidance. You can do follow-up questions. Any concern you have there, by all means, you can write, ask follow-up questions, request the recording, all of that sort of stuff will be a great way to do that. You can also get a lot of questions answered on the website with the frequently asked questions on the page there. Of course, call us, set up an appointment. Consultations are free. We don't charge for that sort of stuff, but you might have some specific things where you just need to talk to an attorney, so you can pay for a consultation where you're actually going to get legal advice. Consultations really aren't for getting legal advice. Sometimes people misunderstand that. Consultations are about determining whether or not there's a good fit, whether or not you would work well with us, can we handle your kind of case, that sort of thing. So we'd love to hear from you. I'm also going to introduce you to the next webinar topic. We do these things twice a month, so I think it's really important to give back education to the community. A lot of misunderstandings and bad information out there. So that's what we're talking about. The nursing home is calling, now what? So I do want to focus on what is called crisis planning or emergency planning for Medicaid, and help you with some myths and things that might get in the way, mistakes you can make if you're not really sure of what to do. We will have a special question and answer section at the end. So if you're unsure of what to ask and you get something at the last minute, there's still that time reserved for you at the end. I will say that I did have a career before I started into the practice of law. So a little bit about me. I'm former military, was an air traffic controller with the U.S. Army. I then spent 20 years serving churches as a minister across the U.S. in churches, usually around 200 members or so, but I've worked in a lot of smaller churches as well. When I left law school, I already knew I wanted to do elder law, so I did a lot of extra education, quickly got involved with the bar, and actually rose through the ranks quickly and was chair of the elder law section and still train a lot of lawyers. And I'm prominent in 2 national groups of elder law attorneys, helping nationally and trying to stay abreast of rules for every state. Every state's laws are completely different. I'm only licensed in Kentucky, so if you do have an out-of-state concern, I can give you a referral to somebody there in another place that would be credible and able to meet your need. The other aspect, just for giggles, what's up with all these old houses all over the place? Well, that's part of my passion, is to help with historic preservation. And I chair the Madison County Architectural Preservation Trust, but I restore houses myself. So you see 2 of them there on the screen. And though I might seem like I'm the only one in town that knows how to do this, I am not. I got a great staff behind me that is very skilled. And so when you come into the firm, you've got a lot of people that are assisting you, and you can see there the kinds of things we do. If you're needing bankruptcy or divorce or speeding ticket help, I can't help you. It's not what I do. It's not what I know. I'm an expert in these things here, and that's the limit of that. So with those things on the table, let's get into this. What are we going to learn tonight? Someone calls, whether it's the hospital, a nursing home, adult protective services, a family member, and you say, hey, your loved one or your spouse, you yourself need to be placed in a nursing home. Now what? Well, first off, Panic sets in because that's the last place most of us ever think we're going to end up is in a nursing facility. But a lot of times other things will start happening. We start taking action to deal with this crisis. If you go to a nursing facility, and maybe there's representatives from a facility on the call tonight, I don't mean to offend you, but my experience is after a decade in doing this stuff is the facilities can often give you misinformation, mistakenly so, sometimes on purpose and sometimes just to bully you. So you can get bad information from attorneys as well. You get bad information from the Medicaid office. Believe it or not, they don't even understand their own rules. So you need to be very careful. You start to take action and you can do things that will harm you. The good news is that you can always reverse those accidents and those mistakes that you've made, but it still is more costly. Time has been lost and things like that. I was sitting with a family today and looking at their circumstance with a family member in a facility right now. Every 30 days delay for them costs them $15,000 at a very bare minimum. It could cost them more if they spend money in other ways, but just time alone cost $15,000 for most people, not just this family. So time is of the essence. So we're running and trying to make choices quickly, and you make mistakes. So that's what we're going to be dealing with. Now, what are we going to learn? We're going to learn what the most common bad decisions and choices are and how to avoid those. We're going to look at the Medicaid look back, what the qualification standards are, and what you can actually do when you're getting some of this negative pushback from a facility. So let's start there. I like those things first. Medicare rules. Most of us are not really sure what the difference in Medicaid are and how that stuff works. So we hear something about Medicare paying for long-term care. Medicare does not pay for long-term care except in very narrow circumstances. Medicare, if you go straight to a nursing facility, a nursing home, from home, Medicare pays nothing. They will only pay if the 3-day rule applies, and that is that the immediate 3 days prior to entry into a nursing home is accompanied by a hospital stay with full admission. So you were fully admitted to the hospital for 3 days and went straight to the nursing home, then Medicare will pay. Now, what happens is generally you're going to be going, most common, from some sort of a surgery or a hip is fractured, something like that. So then you go over to the rehab unit. The Affordable Care Act gave us some real help here. And on this next stage, I'm in rehab, you get Medicare for 20 days. On day 21, you go private pay for that care unless you have a Medicare supplement, and that will extend you through day 100. However, the prior rule before the Affordable Care Act was you had to be making progress. Without getting too deep into what progress was defined as, the bottom line is if I have dementia, I don't make progress. If I have dementia or Alzheimer's or something like that, it's always going to get worse. It might stabilize for a while, but it's not going to get better. And therefore, insurance companies use that rule to say, without making progress in dementia, we're not going to continue to pay for this 100 days. The point is this: 100 days is not a guarantee. There are conditions. So the current rule under the Affordable Care Act is 100 days if that continuing care is essential for stabilizing. So as long as I can keep status quo. So it's not guaranteed. If I have a family member who refuses to eat and they're declining, they stop paying. So your 100 days is never a guarantee. And in fact, a lot of times it's not even helpful. If we know that we're long-term going to need to move on to Medicaid, I'd rather people go ahead and let that 100 days lapse and go private pay so we can get on with implementing a plan and saving the family money. But oftentimes families want to appeal and take full advantage of their 100 days, which I often find to be counterproductive. But that is the rule. The 100-day rule is 20 on Medicare. And then if you have a supplement, you get an additional 80 days or a full 100. Now, a second thing that I want us to think about, hey, the nursing home is calling. What do I do? Usually there's going to be some sort of a residence rights issue, a violation. You may not have ever heard of residence rights. This is something that was promulgated at the federal level out to the states. And so every state has some form of what the federal rule was. Now, these apply to both the hospital and they also apply to the skilled nursing facility. So, number one residence rights rule is when a healthcare facility takes you in, they have the responsibility to either meet your medical need or find you placement in a facility. That requirement to find you placement is worth its weight in gold because it can be very difficult to find placement a lot of times. Now, if you decide to go pick mom, dad, spouse up and you take them home, they no longer have to take you back. So if dad was a little cranky or they just found because of a lack of mobility, there was an extra strain on the staff to take care of your loved one, the nursing home has no legal obligation at all to allow you into the facility again. So they often will exercise that right and simply say, no, we don't have availability, which could mean just simply, we don't want you. All right. So if they already have your family member, your loved one in, keeping them in that facility is really important because they have the responsibility to make any sort of transfer to find placement. Dealing with a family just this week where they've had a person in the hospital for 4 months and cannot find placement. So guess what has to happen? The hospital has to continue to provide that care. And who pays for the care when they're in the hospital? Medicare does. So they're continuing to get Medicare payment that they would not otherwise be eligible for if the transfer occurred. And the hospital wants that transfer to occur so they can go ahead and open their facility up to more patients. Very important that they continue to exercise the residence rights enforcing placement. Another residence right is a healthcare facility cannot evict you. Oftentimes, you'll get a call from the nursing home that says something like, your Medicaids are running out and we're going to have to evict. They cannot evict. There's only two circumstances that you could ever be evicted for, and that is if, while they're providing care, you refuse to pay them, and if you are Medicaid eligible, have run out of money, any of those sorts of circumstances, as long as you have applied and are seeking that approval, then they can't evict you there either. So either you have the money, you are paying, or you're seeking a Medicaid or even a VA benefit, then they cannot evict. But they'll often play a game and say, well, we're going to, and use the evict word, and it confuses the family. And so the family member is scared. I don't want to put mama on the street. So they go and pick you up, your loved one up, take them home. And now what? You don't have that placement service being offered to you. So it's very important to understand what's going on. If you remove the loved one, then you're assuming all responsibility, and they cannot harass you for payment under any circumstance. As long as you're making an effort to paying a little something, they cannot harass. There's all sorts of fair credit protections for the family on that. And family does not assume the liability for payment on behalf of another. If dad doesn't have enough money, mom doesn't have enough money to pay for her own care, it doesn't fall on the children, for instance. So what kind of responsibilities do, I don't have a slide for this, so I'm just going to talk here for a second. What responsibilities do apply to family? A lot of times I meet families that say something like, well, I just can't stand the idea of putting mama in a nursing facility. I want her to stay at home as long as she can. Do I assume any liability for mom? Yes, you do. Anybody who knows or should have known of the liability to harm herself, fall and become injured, harm others, is responsible for that person. So if mother has some dementia or Alzheimer's and she wanders outside, or she gets disoriented, still can drive, but gets disoriented, get lost, if she has an accident and the family members were aware of that, there can be liability for that. If adult protective services are ever called, and any person in the public can call APS and say, look, I think my next door neighbor needs whatever kind of explanation they want to give. there has to be an investigation that is started, at least with a phone call. And at that point, if they actually find that there is a need, APS can come in and they can initiate guardianship over your loved one, take them out of the home, put them in placement, seize the assets, seize the income, bank accounts, and make payment to themselves for the services they're providing. So if there's a family member you have who needs help, being in denial about it is very tempting, but it's a dangerous path to go down. We need to be very open and honest in the family and talk about these things so we can actually take care of our loved one with the best possible choices. So APS, Adult Protective Services, are there to help us. I don't want to paint them negatively, but it is something that can happen. Intervention can come in. Secondly, I would say a word about guardianship here. It's always very important to take action as early as you can. If a person declines to such an extent that they can't do their own legal planning, they cognitively decline, we don't have a power of attorney, we don't have financial safeguards in place like a trust or something like that. The only alternative you would have is to go to guardianship court and have all of their civil rights removed and another person placed in supervision over them. So I'd rather act early with a power of attorney where we're all in agreement instead of having to go through that, what can often be a very messy process with the guardianship court. It's good when we have to, but it's always unpleasant if we had other alternatives available to us. So before I go deeper into Medicaid, are there any questions out there so far? That was a lot to cover with residents' rights and Medicare. Anybody want a question or two before we go deeper? Alrighty. Either we're scared to death to ask the mean old lawyer any questions, or I'm doing a great job. So, hey, bonus either way, right? So who qualifies for nursing home coverage? Anyone in the state of Kentucky can become qualified for nursing home coverage under Medicaid, with the single exception if your income is higher than the cost of the nursing home. So right now, the average cost of care is well into the $9,000 range. Last year, it was averaged at $9,600 a year, or sorry, a month. If my income was $9,600 per month, I don't have the need for Medicaid, therefore I will not qualify. Even that has an exception to it. If my spouse needs some of my income to survive, I still could qualify to give some of my money to my spouse. But other than that, anyone can qualify. Now, the Medicaid cap is $3,082 is the income standard to qualify. But still, if I make $3,500, there is a federal rule using a qualifying income trust, or if you're familiar with an older term, a Miller trust, to qualify. So anyone can. It's really what your income standard is as to whether or not it's beneficial to you, really, or not. Now, there are asset standards. Those are a little bit more tricky, but those are actually to be planned around. So you could still qualify. It's just how quickly would you qualify and how much money could you save? So here's the rule on the assets. The person applying can only have $2,000 to their name. So early on, I said Medicaid is going to not give you accurate information. Just because you have more than $2,000 to your name doesn't mean you cannot qualify. You could take your assets and transfer them into excluded resources and still qualify. In fact, if you can't do that, there's still ways around it. So I usually tell people, no matter how much you own, we can save half of that and still get you qualified, even if you're a single person. Most of the time, if you're a married person, we can save you between 70% at a bare minimum, but most of the time, a married couple can save 100% of their assets without any trouble whatsoever. So this is a tricky slide here, talking about income and assets, because generally speaking, we can save just about all of the money. But the real rule is $2,000. Most folks, however, are not as concerned about their money as they are their house. So there are 8 ways to save the house. A married couple, the spouse that's still at home gets the house free and clear. There's no question. The only problem with that is what if the second spouse, the one still in the community living at home, also declines and needs care? Then the house is back on the chopping block. So you turn to your other 7 ways to save the home. There is always a way to save the home, period. Medicaid's rule is once approved, you have 6 months to sell the home. Then they want you to spend the sale proceeds on your care, but you don't have to do that because they give you 7 other alternatives of ways to use the home. So if you want to keep your home, there's always a way. And I just wish that people knew that. It seems to be a lot of bad information out there about the home. So the most common, talking about a panic or a myth out there, people see mom, dad, grandma going downhill. They panic. We got to do something because we've heard about all this stuff with the home. So they take the home at least 2, 3 times a month. I hear families have talked to another attorney, and that attorney says, transfer that to your children's name. Never do that. The moment you do that, you've instantly given away your capital gains exclusion. So I'm going to bore you with math because this is such a big problem. Let's say mom and dad bought their house in 1980 for $100,000 and they're going downhill. So they decide they're going to put that house in my name. But that house nowadays would sell for $300,000. That means it gained value of $200,000 of capital. That gain, whenever I take the house, if I sell it sometime in the future, I'm going to be taxed at 20% on that $200,000 gain. That means I'm going to spend $40,000 on taxes because that attorney didn't know what they were talking about and told us to put the house in the kid's name. If you used a trust, you would keep the capital gains exclusion and pay zero. That's a $40,000 mistake. Why did we make this mistake? Because we panicked and went to, I don't know, the guy that did my divorce or whatever years ago and helped me with my last legal issue, but they didn't specialize in this area of law. So mistakes come in very quickly. Lawyers can't be experts in everything. So go to someone who really knows this area. So that the panic decisions can be very costly. Not only would you run the risk of capital gains exclusions, you lose your property exemption, so your homestead exemption of $46,000 reduction of the property tax value is gone. But other things happen. You automatically get a penalty because of the 5-year look back. So anytime we give something away for less than fair market value, anytime within the 5 years prior to needing nursing home care, Medicaid is going to assign a penalty for that transfer. So I'm going to stick with my same analogy of this house. The house was worth $300,000, putting it in the children's name, and let's say I made it 2 years, 3 years, 4 years. If I don't make it the full 5 years, the same problem exists. You take the average cost of care per month, $9,600. Let's just make it $10,000 so we can do easy math on the top of our head. $300,000 house divided by the $10,000 a month penalty number means that I get penalized for moving the house to my kids' names for 30 months. In other words, for 30 months, I will be ineligible and I have to find some other way to pay that nursing home bill because I put the house in the kids' names. Not a good idea. So that could be reversed, but we still have to restart the capital gains window. So bad choices. What we really want to do is learn about permissible spend downs. So I can do so many things to make sure that we save all of our money, get exempt transfers. We're going to look at the tax picture to make sure that we're in the best possible position there. Most of the time, we're going to use a trust, but not always. There could be other ways to do this. But there are lots and lots of ways to make sure that we save at least half, if not 100% of everything you own and still get the Medicaid qualification. I will do other webinars where I go through exactly what these permissible spend downs are, but I just want to give an overview tonight as we're going through all of this. For me, the absolute bottom line is to get the best care possible. But the second highest priority for us is to save you as much money as possible. So when you sit down with us, the very first thing we're going to do is say, what's most important? Is it the cash? Is it the house? Is it the farm? Because many of our parents are going to own more than one property, and it might be farmland or the residence. Both of those are likely to be saved without any concern, but we still want to say what is the family's priority, and then we work from there. So I did say a second ago that Medicaid uses this 5-year look back. They're going to look at anything transferred as something that can be penalized against you. So giving away the house, giving away a vehicle, those are all bad ideas. But where most people miss it is they don't realize that gifts of money. So let's say a gift to a grandchild for college graduation, or even the money that's being spent at holidays. We just went through Christmas, right? What if you gave $100 to two or three of the grandkids for their Christmas gift? That's all a penalty. And Medicaid is going to discover that, and Medicaid is going to penalize us for it. I've even seen Medicaid penalize tithes to church and charitable donations and things like that. And they do look at every single transaction on your bank statement. Often will require you to even go and get a full 5 years worth of bank statements and submit them as part of the application. So that they mean business around these sorts of things. If you do some sort of selling of the house or car, let's say I got a pickup truck and I want to sell it to my grandson, but I want to give him a discounted rate. That discounted rate means the truck was worth $5,000. I sold it for $500. Well, I gave away $4,500 worth of value, and I'm going to be penalized half a month for that. Here's one thing that does confuse people, or maybe it's just a misunderstanding. Oftentimes I'll hear people say, well, things are protected once they're in a trust, right? Well, not in a revocable trust at all, but in an irrevocable, yes, they are protected. The transfer to the trust, however, is still penalized unless it's a special third party or first party supplemental needs trust. So you got to be careful with your transfers, and there are all sorts of ways to mitigate any penalty, but you want to protect with a trust, but you also have to have somebody that's skilled enough to know how to offset the transfer itself. So it's a two-part process. So let's see, maybe I'm going a little too much and being repetitive here, but blindly spending down assets destroys your Medicaid eligibility. And that's what the nursing home is going to tell you. And in fact, they don't oftentimes even let you know it's happening. Many nursing homes contract with non-law firms, so they will file your Medicaid application for you for free, but they put no preservation strategies in place. The reason they file the application for free is because you're going to do exactly what this slide says. You're going to spend down all your money, save none of it, all the while you're still paying full price for the nursing home, which is a higher rate than what Medicaid would pay them. Medicaid has a negotiated rate. That's why you'll find these companies, and there's 3 or 4 of them that service the state of Kentucky. Most of them are from out of state. The biggest one is down in Clearwater, Florida. They do this for you for free. Why? Because they get a kickback from the nursing home, because the nursing home is making a higher rate from you if you stay private pay for longer. So it is going to save you money, going to keep more money in your pocket. Go see an actual legal authority and not some third-party non-legal entity. They're not working in your best interest. What you want to be searching for are legal strategies that exist that save these things and protect them. So we're going to use home exemptions to do a lot of work on that and save the house and keep your taxes. But you also need to be aware that you have a second thing that's going to happen in your case, and you need to make sure that the people you go turn to are very skilled in Medicaid estate recovery. Once Medicaid starts paying the bill, they have an automatic claim to seek reimbursement from your estate once you pass away. That's what estate recovery means. So Medicaid estate recovery does have exemptions. We can get around it in lots of ways. If you plan correctly on the front end, it doesn't ever come up on the back end, but it is something that you need to be aware of, because in a do-it-yourself approach, you're not protecting yourself against estate recovery at all. And how much are they going to ask for? They can ask for the full amount that they ever gave you in benefits. So it can be hundreds of thousands of dollars they come against the estate for. Skipping on along, I want to make one distinction. So, practical steps in what we've been talking about mainly is crisis planning. In this area of law, usually you have what is called pre planning and you have crisis planning. So, I want to say a word about both, and then I'm going to go to question and answer with you. If you were to ask me the question, Scott, when should a person start planning for something like this, or when is it too late to plan? I would say number one, it's never too late. This past week, people that have been privately paying in a nursing home for almost a full year. Great. Is there money still left we can save? We can help. It's never too late. Anything that they still have, the same rules would apply. 100% if they're married, 50% as a minimum, but most likely 70 if they're a single person. But it's never too late. Even if we're already with cognitive decline and things like that, still it's never too late. But when should you start? When you're headed toward retirement age, or whatever time frame, if you have some sort of family history with cognitive decline, dementia, Parkinson's, Alzheimer's, whatever tends to be the time that that starts showing up in the family, you want to do it as soon as you can, around the 5 years in advance of when that starts to happen in your family. So otherwise, I would say around retirement age, but when we're hitting our mid 60s, it's time to start planning. I would want you to do some pre-planning early. Everybody on the planet from age 18 on needs to have a power of attorney in place. As an adult, whether married or single, no one has legal authority to make healthcare choices for you if you're in an accident. So a power of attorney is hugely important. A will. If you're married, children, you need to be able to say in your will who you want taking care of your children, who's going to take care of the money for the children, anything like that. Those things need to happen for all young adults. Otherwise, we really need to have all of that more advanced planning, like I'm talking about, no later than the time we hit retirement. If you have more sophisticated investments, have rental property or own a small business, something along those lines, you need to have a more sophisticated trust-based estate plan as soon as you're investing. I really do appreciate you being here. I hope I've helped you, met some needs for you. I've never even mentioned the QR code that's been staring you in the face, but if you didn't mind leaving a Google review, that's really helpful for us getting the word out to more and more people. All you do is scan that with your phone. It'll give you a little button to push, and you can go and leave a review to say, yeah, these events are super helpful. And that will do a good job for other people.